Hello, and a warm welcome to all of you joining us today for the PHAP online web seminar on international criminal law. I'm very pleased to have with us Chris Jenks, and before we get to the substance of today's session, I'd like to take just a moment to run through some housekeeping details. First of all, for any of those of you who are new to us, we are running a series of online web sessions looking at humanitarian law and policy. We have recorded our previous sessions, so if you're interested, you may access these recordings as well as the optional assessments that are available following recordings at the PHAP website, phap.org. We have a number of very interesting sessions covering topics such as qualification of conflict, the conduct of hostilities, humanitarian principles, etc. So I would encourage you to check out the recordings available at the PHAP website. Also, for today's event, as you can see, there's a very engaging interactive chat on the left-hand side of your screen. If you'd like to pose a question to the presenter, we'd encourage you to use the Q&A column, which is found to the right of your screen. So please do at any point during today's session, submit a question for our presenter, and we will do our best to pose those live today. And in the event that we're unable to cover all of the questions, we will do our best to then address those either bilaterally or online through the PHAP website. If you do encounter any connectivity problems during today's session, the session is live streamed at phap.org. We would encourage you, however, to stay with us on this platform because this platform offers the interactivity element that is absent from the live stream. Also, as you can see in the chat on the left-hand side of your screen, Marcus has provided some links for a call-in as well as the link to the live stream. And so without any further ado, I'd like to introduce today's session with today's guest expert. We will be addressing international criminal law and its role in addressing violations of international humanitarian law. And I'm very pleased to have with us today Professor Chris Jenks. As we've indicated previously, PHAP provides learning objectives ahead of each session to ensure that there is accountability on our end so that you know what we hope to cover in today's session. And so what we hope to address for the ICL session today is first an appreciation of what can be a rather complicated relationship between international criminal law, ICL, and international humanitarian law, IHL, and the role of ICL in supporting the enforcement of IHL. We also hope to have a familiarity with the main legal instruments, i.e. treaties, as well as mechanisms, courts and tribunals, of the international criminal law framework. We hope you will gain knowledge of the main elements of the crimes of war crimes, genocide, crimes against humanity, and the crime of aggression, an understanding of the jurisdictional scope, as well as the general legal principles that undergird the ICL framework. And lastly, we hope that you'll gain an appreciation of the challenges to the application of international criminal law in contemporary contexts. We have Chris Jenks with us this morning, and with that, I will turn it over to Chris.
Good morning, good afternoon, and good evening to those around the world. It's neat to see the different parts of the world that people are logging in from. Obviously, morning here in the U.S., afternoon in Europe. Particularly glad that some of our colleagues from India, Afghanistan, and Australia have been able to participate, recognizing that the timing is maybe a bit more challenging depending on where in the world you are. I first want to thank PHAP and Beth and Marcus and the organization, both for what PHAP does in general and for this opportunity to present and talk with the group today. As Beth indicated, the learning objectives, and those are, you should see on the slide on the screen. What I'm hoping to do today for about the next 20 to 30 minutes is clarify some terminology in the hopes of helping to inform those of you that maybe aren't practicing in the field but are interested in the subject. But for those that work for organizations that perform humanitarian functions, my goal is to help you operate, to help you communicate more effectively with other non-governmental organizations, with militaries, with armed groups, and really to facilitate your ability to accomplish the humanitarian work you and your organizations perform each and every day in conflict zones around the world. So just as to start out, we're going to be talking about the relationship between international criminal law, ICL, and international humanitarian law, IHL. So those are both subsets of international law. When we talk about IHL, what I'm talking about is the law that governs the conduct of hostilities versus international criminal law is the mechanism by which the international community has determined what conduct should be punishable or should be considered criminal. So when we're talking about IHL, we're talking about regulating the conduct of hostilities. So this is body of law you may be familiar with, use in bello. We are not talking about the UN Charter. We are not talking about the legitimacy of resorting to force or use ad bellum. And it's interesting to keep in mind that international criminal law regulates a broad subset of conduct. Some of the crimes under international criminal law require the existence of an armed conflict, but certainly there are international crimes which do not require an armed conflict. For our focus today is on that portion of international criminal law which draws from and criminalizes violations of international humanitarian law. And there we're speaking of, for the most part, a couple of international agreements. The 1907 Hague Convention, the Geneva Conventions, and the additional protocols 1 and 2. One useful way to keep these straight or distinguish between them is the 1907 Hague Convention largely regulates means and methods of warfare, while the 1949 conventions is more protective oriented and relates to providing protections for those that are no longer participating in combat or armed conflict. Excuse me. The 1977 additional protocols, the first and second, are often thought of as a blending of Hague and Geneva law. So if you hear references to Hague and Geneva law under IHL, Hague is a means and methods. You can't use poison weapons, for example, under Hague, and the Geneva Convention's more protective. While the 1907 Hague Conventions are obviously well over a century old, much of what is contained in the Hague Conventions is still very relevant today. There have been prosecutions in the International Criminal Tribunal for Rwanda, for example, where essentially someone was found guilty in the late 20th century for a violation of that 1907 convention. So don't let its age lead you to think that it is no longer relevant. We also have another body of law, customary international law. The challenge with customary international law is it is practice-based, and so it is not codified as such in a treaty. It's relatively easy to pull up and access the Hague Conventions, the Geneva Conventions. Customary international law is subject to some interpretation and some debate about what practices are so commonplace, so customary, that we would say they have the force of law. And then finally, well, not the subject of our conversation today, you have the intersection of international human rights law, which the triggers for when that law applies and how it applies during an armed conflict are very much debated and the subject of a lot of scholarship. In terms of the mechanisms, how does international criminal law enforce the accountability provisions of international humanitarian law? And here we tend to think of international criminal tribunals as the main mechanisms for the enforcement of international criminal law. And I'd like you to, I should have put an asterisk on this slide. I'll come back to this towards the end and ask you whether or not these really and truly are the main mechanisms. But here we think of the International Military Tribunal, which is actually the formal term for the Nuremberg tribunals, which followed the Second World War. That's the modern day precursor to what we have in the form of international criminal law. So we had, shortly after World War II, we had the International Military Tribunals at Nuremberg, and then we had a gap of several decades before our next mechanism, which were the International Criminal Tribunals for Yugoslavia and also for Rwanda. Those tribunals were significant for a variety of reasons, one of which is that they dealt with non-international armed conflict. Obviously, World War II was the most international of armed conflicts, being a world war. But the International Criminal Tribunals for Yugoslavia and Rwanda were significant in applying international criminal law to a non-international armed conflict. And following the ICTY and ICTR, there have been a host of specialized or hybrid tribunals, Cambodia, Timor, Sierra Leone, and frankly, a number of others. And then, of course, we have the International Criminal Court and the cases and situations that the court handles. So those are the principal international mechanisms for the enforcement of international criminal law regulating international humanitarian law. I'm going to talk very briefly, and in fact, you'll have these slides available for you to go through, as I don't want to read the elements of these offenses. I'll highlight a couple of the terms that are in them, and then we can certainly, to the extent there are questions later, we can address them. The first is war crimes, and you see that I have that term in quotes on the slide. At the outset, I would tell you that the term war crimes is a dangerously deceptive term in my view. And why do I say that? I say that because in my experience, when we use the term war crimes, it sounds like it is a specific term. But it's actually, while sounding specific, it is actually quite vague and quite general. And so it is oftentimes there will be a conversation where one person is talking about war crimes and they're actually talking about something very different than the listener understands them to be. And I'll provide you some examples here in a moment. But not surprisingly, war crimes do require the existence of an armed conflict. So if there's not an armed conflict, there can of course still be criminal misconduct, but it wouldn't be properly characterized as a war crime. My suggestion to the audience is you should not use the term war crimes by itself. You should either refer to grave breaches of a Geneva Convention, you could refer to a violation of the Hague Convention, or you could refer to a war crime as defined by the crimes of the ICC or tribunal. So if you ever hear someone say war crimes, you should think and even consider acting war crimes according to what? War crimes as defined by Article 8 of the Rome Statute? Do you mean war crimes as in a grave violation of the Geneva Conventions? What do you mean when you're saying war crimes? As a general proposition, war crimes is often used, though, to refer to grave breaches of the 1949 Geneva Conventions. Each of the four 1949 conventions, towards the end of the convention, actually tells you what the grave breaches are. And there's considerable significance to the concept of a grave breach. So a grave breach is the most serious violation of the convention. And when a grave breach exists or occurs, that triggers an obligation to a country to either prosecute, to bring the individuals before their national courts or surrender them to another national court. But that is only for grave breaches. There's a common misunderstanding that all violations of the Geneva Conventions are either war crimes or that all violations of the Geneva Conventions are grave breaches. There are a number of ways in which a country or specific individuals, members of armed forces, could violate the Geneva Conventions in a manner that does not constitute a grave breach. Now, for those lesser, non-grave violations of the Geneva Conventions do impose a requirement on states, but it's a different requirement. So remember, when the violation is grave, and think, for example, murder, the obligation is to bring someone before the national court or surrender them to another country. For the other violations, these less than grave breaches, the obligation under the Geneva Conventions is to take actions necessary to prevent those lesser violations from reoccurring. When we talk war crimes in the Geneva Conventions context, we're talking about grave breaches of the Geneva Conventions, violations of the convention, or you may be referring specifically to a section of the International Criminal Court or one of the other tribunals which have laid out what is considered war crimes under those statutes. So moving on to genocide. Important to remember, genocide is a crime under international criminal law that one can commit regardless of whether there is an armed conflict. And we talk genocide, we're referring in broad terms to the intentional destruction of certain groups. And after World War II, while genocide is not addressed as such in the conventions primarily, it is the subject of the 1948 Genocide Convention. And I'll just leave on the screen for a moment the definition of genocide from the 1948 Genocide Convention. As you're reading through or looking at those elements, The element that ends up becoming the focal point of a lot of litigation and debate is not so much, frankly, the underlying acts that you see in the bullets. So killing members of the group, unfortunately, is often easy to establish. So it's not so much that whether or not, it's not a question of whether or not killing members of the group has occurred. It's a question of whether or not killing members of the group was done with an intent to destroy. So you see the italicized language. It's that intent to destroy in whole or in part that is proved one of the contentious issues or the challenges in trying to establish a charge of genocide, and then as well as what constitutes a national, ethnic, racial, or a religious group. Perhaps better left for questions, but I would, because a question for the group is whether or not our international community's efforts in the Genocide Convention of requiring states to take action when genocide occurs have had a unintended second or third order effect, in that you see countries today seeming to go out of their way to not call acts that appear to be genocide because they can't or are unwilling to follow through on the obligations that everyone signed up for in the Genocide Convention. Shifting to crimes against humanity, again, another international criminal law offense that does not require an armed conflict. One can certainly commit a crime against humanity during an armed conflict, but an armed presence or existence of an armed conflict is not required. And you see here, in fact, I don't even have all of the ways in which one can commit a crime against humanity listed. This is most of them, and I'll let you take a look at those. Similar to trying to establish genocide, the underlying acts of, say, murder or torture aren't necessarily the most challenging part in making out a case of crime against humanity. It's whether or not those acts occurred as part of a widespread or systematic attack. So there's cases that discuss and debate what constitutes widespread and what constitutes systematic. And also, again, has to be directed against the civilian population as opposed to just unintended effects impacting the civilian population. And then lastly, the crime of aggression, one of our more recent codified international crimes. This has now been added to the Rome Statute courtesy or through the review conference in Kampala in 2010. And the international community, the states parties to the Rome Statute, are still in the process of signing up for essentially the element of, or the crime of aggression. And it will be several years before we get a sense of how the crime of aggression is used or is used at the International Criminal Court. But you see on the screen the elements of the crime of aggression under the Rome Statute for the International Criminal Court. So jurisdictional scope, and I know we have a number of non-lawyers, and what I could tell the non-lawyers is not even the lawyers want to hear lengthy discussion about jurisdiction. It tends not to be one of the more enjoyable aspects of legal training, and so I won't belabor the point, but just some broad concepts to keep in mind when we're talking about jurisdiction. So I think it's helpful to keep in mind jurisdiction is thought of in at least two ways, and I've broken them down as you see on the screen. One is jurisdiction over the crime, and that can also have a a temporal component. So if you look at the International Criminal Tribunal for Yugoslavia, its jurisdictional scope tells you what is the time frame, what kinds of crimes or alleged crimes that occurred in what time frame fall under the International Criminal Tribunal for Yugoslavia. And for those crimes, either those crimes or the timing, when it falls outside that scope, what that means is then that tribunal doesn't have jurisdiction. So for example, with the Rome Statute entered into force in 2002. So depending on when a state has signed up for the Rome Statute applies no earlier than 2002. So if the matter or case that someone thinks the ICC should handle occurred in, say, 1995, the International Criminal Court would not have subject matter jurisdiction. So you can look at the statute of a tribunal or the ICC, and it will tell you kind of the parameters, both of it's these kinds of offenses and it's this kind of timing that we are able to deal with. A little known lost fact about the International Criminal Court, for example, is at the outset, the idea of the International Criminal Court was initially envisioned as handling drug offenses, international narcotics offenses. In the debates that followed, that led to the establishment of the International Criminal Court, the International Criminal Court does not have jurisdiction over the drug offenses that at least several countries initially envisioned that it might. So you want to look at the statute that establishes a tribunal to get an idea of what kinds of crimes and what timing of those crimes to see whether or not it is even in the realm of the possible or permissible for the tribunal to handle it. And then personal jurisdiction. Personal jurisdiction is quite literally, do you have the person? Do you have control of the person to potentially be prosecuted by the tribunal? So you want to distinguish between jurisdiction over the offense, including timing, as well as jurisdiction over the person. I want to shift now to a contemporary challenge and try to relate it back to some of the work that I know a lot of you and your organizations perform. And my question at the outset is, or my comment at the outset that you can certainly correct me on in the question period is, I wonder if a number of you are disillusioned by international criminal law. Perhaps you've operated in or near conflict zones. You've encountered frankly, some bad actors, people that are disruptive to the peace process, people that maybe even have committed violations of international law, of everything that you've been taught. And you may have thought to yourself that there was little to no chance that this person or these people were going to be called to account in an international tribunal. And I can only imagine how depressing such a setting must be. And I'm here on the one hand to agree with you if that's the view that you have, but I want to try to point out why I think how I think we've ended up in the place that we are currently in terms of international criminal law and some of the frustrations I think a lot of us sense at international criminal law. And so my comments are on really the challenge of accountability today in an era of non-international armed conflict. So these are conflicts that don't involve a state fighting another state. These are internal armed conflicts. These are civil wars. These are non-state actors fighting either other non-state actors or a state itself. And my point is, I think we collectively, the international community, which is very aptly represented by the diversity of participants on this webinar, I think we have inverted the role that these international tribunals play in accountability. And I think we're asking international criminal law in an international setting to do too much. In essence, that we're placing an unbearable burden on our international criminal tribunals. And I would ask, consider the International Military Tribunals, the IMT at Nuremberg. Of course, very significant legally and symbolically, but I think we've lost our perspective on the relatively small role that those tribunals played in accountability after World War II. Why do I say that? The IMTs prosecuted 200 individuals, roughly. The United States, France, Great Britain, and the then Soviet Union, in individual national military commissions and military courts, prosecuted close to 10,000. So individual states prosecuted 10,000 after World War II, while the international effort only prosecuted roughly 200. So these national proceedings, I submit, provided overwhelmingly more general and specific deterrence and punishment of offenders. Now, I'm not suggesting that we don't need international tribunals. There is very much a narrow and specialized role and need for such proceedings. But my point is, for us to have a viable accountability framework, we need exponentially more national war crimes cases than international. But many states, including the United States, are largely unwilling or unable to hold such prosecutions. And if you move forward from the international military tribunals to the ICTY and the ICTR, in Rwanda, the International Tribunal indicted just under 100 people, while Rwandan national courts prosecuted 10,000 and other national processes over 1 million. And in the ICTY, the International Tribunal has charged 300. The hybrid and other tribunals which have followed have largely been accompanied by little or no domestic prosecutions. The International Criminal Tribunal is increasingly becoming the sole international criminal justice mechanism. So gone is our 50-to-1 ratio, and left is the 1. And so I think for us to claim now that these infrequent proceedings provide much in the way of deterrence or accountability is a weight that simply cannot be borne by the international mechanisms. So what has changed over the last couple of decades is the drastic increase in the occurrence of non-international armed conflict. That, coupled with ease of travel and fewer border restrictions, means it is increasingly likely that former belligerents who allegedly committed war crimes in a non-international armed conflict somewhere will reside in a country not a party to that conflict. So when a Syrian army officer or a genocidaire winds up in your country some years down the road, ask yourself whether or not your country has jurisdiction and would be willing and able to prosecute that offender. If you're a country like, say, Canada, you can credibly say the answer is yes. If you're a country like the United States, unfortunately, the answer is no. So when we look to international criminal law, we need to first look to ourselves. The role of enforcement and accountability that international criminal law plays should first and foremost be done through national prosecutions. International tribunals should be a last resort and an exceptional circumstance. And I think perhaps some of our frustration is that over the last 20 to 30 years, we're placing increasing, if not complete, reliance on these international criminal tribunals. And again, that's simply a weight that they cannot bear. With that, I will turn it over to Beth and look forward to your questions and comments.
Excellent. Thank you very much, Chris. Very appreciated. So for those of you who are interested, those PHAP members who are interested in taking the assessment, the code that you'll need to access it is 1521. Again, that assessment code is 1521. And with that, I'd like to move over to the Q&A session. We've had a number of excellent questions coming in during today's session. And a number of them have something to do with the notion of grave breaches and the obligation to prosecute or extradite. So if you allow me, I'm going to pose a question that I hope presents a number of these questions. So Chris, you addressed the concept of war crimes and the link to grave breaches, as well as the obligation to prosecute or extradite under IHL. Could you explain just a bit more the application of the grave breaches regime vis-a-vis an international armed conflict versus a non-international armed conflict? And does it matter if there's an international or a non-international armed conflict for there to be a grave breaches regime? And if it does, what does that mean for the obligation to prosecute or extradite? Is that then only linked to an international or non-international armed conflict?
Thank you, Beth. Yeah, a number of good questions rolled into that. So to speak a little bit more precisely, what the requirement under the Geneva Conventions is for a grave breach is to bring such persons before its own court. So it may be that a country, a state, conducts an investigation and decides that prosecution is not warranted, or it may be that there is a prosecution and there is an acquittal. So the requirement is not conviction or even necessarily prosecution. It's to bring before your own court system. But as part of that question indicated, when I'm talking about the 4 Geneva Conventions from 1949, those apply to international armed conflict. And one of the challenges that we face today is this kind of perverse imbalance between the frequency of the type of armed conflict and the applicable law. So the vast majority of the codified, the black letter law that we have regulating, of IHL, the Hague and Geneva Conventions, 90+% of that deals with, as a matter of law, with international armed conflict. Very little of the black letter law deals with non-international armed conflict. And you have to juxtapose that against the unfortunate reality that the kinds of conflicts that are occurring are exactly the opposite. In fact, some studies have shown that since World War II, of the armed conflicts that have occurred in the world, over 90% of them are non-international. So the conflicts that occur most frequently have the least amount of law that applies as a matter of law. Now that's where customary international law can and does play an important role. The issue, though, is a country would have needed to prescribe or legislate or put in a statute that the conduct is prohibited both in an international and a non-international armed conflict. So some countries, for example, Canada, a number of countries have just incorporated the Rome Statute of the International Criminal into their national system. The challenge of a non-international armed conflict is it would take some implementing legislation by a country to criminalize conduct in a non-international armed conflict that is already criminalized in an international. That goes to that question, Beth.
Great, thank you very much, Chris. Another interesting question in from James, and James asks, have a sufficient number of countries ratified the law regarding the crime of aggression for it to be in force?
The answer is yes. It's just the way that the states parties to the Rome Statute agreed is while there have been a sufficient number of states parties that have agreed to the crime of aggression, it doesn't go into force until 2017. And there's some sense we haven't had this crime under the ICC, and the ICC itself is still relatively new. We're not exactly sure how it's going to play out in practice, but we will start to get a sense of that in the next 2 years or so.
Great, and then another interesting question in from Dylan regarding the Rome Statute of the ICC is the question, Are any of the, let's say, the provisions of the Rome Statute retroactive?
So, not retroactive before the Rome Statute went into effect. So that gets back to our jurisdictional, the jurisdictional scope. So, for example, if we, for a moment, pretend that the International Criminal Tribunal for Yugoslavia and Rwanda never existed. So the Rwandan genocide occurred, the Srebrenica massacre and other atrocities occurred during the war in the Balkans, and now we have the International Criminal Court in 2002. The International Criminal Court in 2002 could not retroactively go back and consider something that occurred in either Bosnia or Rwanda in the mid-90s, because it only took effect in 2002. So it depends on the earliest of either the Rome Statute going into effect in 2002 or when your country signed up for the Rome Statute. So if a country signs up to the Rome Statute today in 2015, one possibility is that state could say, we agree to be a party to the International Criminal Court from this point forward in 2015. And what that would mean is whatever happened in 2014 would not be covered by the International Criminal Court. But some countries who have recently joined have actually said, while we're just joining in, say, 2010, we agree to be bound going back to the earliest possible point. And the earliest possible point is when the Rome Statute went into force in 2002.
Great, thanks, Chris. Could you say a bit more then about perhaps the international criminal tribunals for Rwanda or the former Yugoslavia, for instance, and how that might have worked? I've seen questions also come in about, how could a criminal tribunal address something that took place sort of, in the past when it hadn't yet been created? Right.
That's a very good question, and one of the reasons why the ICTY and the ICTR, are so significant. But of course, consider that the International Military Tribunal after Nuremberg was created, obviously after World War II, and even more controversially, the IMT at Nuremberg prosecuted some Germans for crimes which there was an argument hadn't been generally recognized at the time that they were committed. So returning back to ICTY and ICTR, the early cases at the ICTY in particular were very much jurisdictionally focused about whether or not the court even had the authority under general principles of international criminal law, basic fairness, if you will, to consider the misconduct. And part of it stems from the fact that the ICTY and the ICTR are creations of the United Nations. And the rulings of the ICTY early on were that they did have jurisdiction, that the violations of customary international law could be held against those that committed them, during the Balkans conflict. But that was very much the subject of a lot of challenges jurisdictionally. So it comes down to basic questions of fairness, and the larger the violation of custom, the more the international community seems willing to hold you accountable. If you were to create a very specific law today and then try to retroactively apply it, I think you would run into to challenges. But if you think through what some of the defendants at the ICTY were claiming, their arguments ring a little hollow. So what the arguments of a lot of the defendants were making, it wasn't that what they were doing wasn't a crime. Attacking villages, rape, murder, you can't make a good faith argument that those are not crimes. Their argument was those were only considered crimes in an international armed conflict, and here this conflict wasn't international, so it's not fair for you to hold us accountable because we didn't necessarily know that that conflict was prohibited, that conduct, excuse me, was prohibited in a non-international armed conflict. And the ICTY and the ICTR took, frankly, a dim view of those assertions and held that it was permissible when the violations were of such a customary norm as they were in ICTY and ICTR.
Great, thanks, Chris. So building on that, we have a number of questions coming in, one in particular from Sylvia. And they're asking about the concept of universal jurisdiction that I think you've mentioned briefly during this session today. And they've noted that there is some controversy to this principle of universal jurisdiction, pointing to, for example, the fact that Spain at one point had been considered to be a country that was exerting universal jurisdiction, but as Sylvia noted, that has virtually been dismantled. Would you be able to speak a little bit about the principle of universal jurisdiction and perhaps sort of some of the debates surrounding the application of it?
Absolutely. So the concept of universal jurisdiction, remember on our jurisdiction slide, we talked about looking at a statute that sets up an international tribunal and getting a sense of what kinds of crimes and what time period the tribunal would have jurisdiction for. So universal jurisdiction is a concept that for certain crimes, we all have jurisdiction. There are different bases of having jurisdiction. So I'm speaking to you from the U.S. and U.S. law. If an American is killed or an American is doing the killing anywhere in the world, the U.S. under its law would have jurisdiction, and that's somewhat common, but not that's somewhat common to other countries around the world. But the point of universal jurisdiction, and what you saw with Spain and some other countries, is what universal jurisdiction means is even if the perpetrator is not your national, even if the victims were not your national, these crimes are so significant. We should all be seeking to hold the perpetrators accountable. And so Spain and a number of countries have attempted to essentially assert universal jurisdiction in some instances. But as Beth noted, it's been highly politicized and highly controversial. And that's unfortunate, and I don't see that necessarily changing. But the impending reality that I'm trying to forecast to you is, in this day and age of, easier to cross borders and non-international armed conflicts going on for such long periods, we are all going to end up, there is a number of countries in the world who are going to end up with someone in your borders who is not your national and who did not kill your nationals, but who committed war crimes in a non-international armed conflict somewhere else. And the question is going to be whether or not your country has a jurisdiction to prosecute them. And that was if you're Canada's laws, for example, would allow and have allowed Canada, for example, to prosecute the Rwandan genocidaire who ended up in Canada. But in the United States, unless the perpetrator is a U.S. citizen or the perpetrator killed U.S. citizens, if a genocidaire ends up in the United States, the U.S. would largely be able to do nothing more than deport that individual back to from where they came. So universal jurisdiction is the idea that every country would have jurisdiction over those offenses and should seek to assert jurisdiction over those offenders and hold them accountable. But unfortunately, it has become highly politicized.
Excellent. Thank you, Chris. Now, if you'd allow me to, I'd like to pose a pretty specific question that'll take us back to the elements of the crime of genocide. And so the question in from Daniel is, so can a political group be considered a group for the purposes of genocide, or is that not an identified group under the elements of the offense of genocide?
My suggestion, actually, Daniel, is if you wanna email me, I can send you a couple of cases. But that really is the bounds of genocide. And Beth was pulling up the slide. And what constitutes how do we define a national, ethnic, racial, or religious group? As a general proposition, a political group as such is not going to be considered a national, ethnic, racial, or religious group. But the bounds of what it takes to be or to qualify or not qualify as one of those groups is frankly the largest part of the litigation and debate over whether or not the crime of genocide has occurred, as well as whether the killings or other acts were committed with an intent to destroy. So you can end up with some pretty horrible circumstances where technically if I acknowledge, yes, I absolutely killed members of that group, I just didn't do it with intent to destroy, well then haven't committed genocide. Now I would have, sounds like I would have committed the act of murder, but I just wouldn't have committed genocide without the intent to destroy.
Great. And Chris, while we're looking at the specifics of the various crimes, could you answer the question that often comes up about, is there a hierarchy of crimes in terms of the list that you showed us under the Rome Statute? And along those lines, is there any sort of strategy behind the decision to indict under perhaps crimes against humanity versus war crimes or versus genocide?
I mean, if I were to put them in order, I mean, clearly genocide would be at the top of the list. The crime of crimes is how sometimes genocide is referred to. And again, we're talking about the systematic, intentional destruction of a group, trying to wipe a group, the face of the earth. So genocide certainly has pride of place in a bizarre way in terms of importance of offenses. But as I alluded to during my remarks, one of the odd things that's been occurring recently is genocide is so horrible, and we do take genocide so seriously, and it is the subject of a separate convention, the 1948 Genocide Convention. And the Genocide Convention requires states to do certain things when a genocide is believed to be taking place. And the kind of the odd second order effect, and here I'm only speaking about the U.S. because I'm more familiar with. The U.S., for example, has gone to great lengths to not acknowledge certain actions as genocide, and the belief is that's because if it was genocide as a state's party to the Genocide Convention, which all countries are, then we would be obligated to do something. So in a weird way, the importance and the value that we place on the crime of genocide is having kind of an unintended effect in that we're now kind of going out of our way to not call things genocide.
Interesting, thank you. Kelly writes with a very good procedural question, and that is, if there's a conviction before the ICC, where does, if any, an appeal process take place?
Oh, and actually, let me address Kelly's question in a moment. Beth, I apologize there. Just to follow up in terms of strategies for prosecuting. So that's a really interesting question. Do you, how do you charge as a prosecutor, either nationally or international criminal tribunal? How do you charge misconduct? And we know from the International Criminal Court we know from the International Criminal Court that you need not charge an international criminal law violation. You could charge, say, murder, a domestic law murder, as long as you are charging the same person for substantially the same conduct. That's considered sufficient. And to kind of follow up on that question, some of the international criminal law charges, they require proving different elements. So when you charge an international criminal law violation, you are taking on some additional proof challenges. You are going to have to prove some different things, some more and different things, in your case. So there are some prosecutors who increasingly are frankly want to try to make their proof process as streamlined as they can. And so what you've seen somewhat in the International Criminal Tribunal for Yugoslavia and elsewhere is seeking the most straightforward charges possible, which isn't necessarily always the international criminal law, just because that adds some added elements. And I apologize, Beth, if you could re-ask Kelly's question.
Sure. Thank you. So Kelly asks, if there's a conviction before the ICC, where, if any, might an appeals process take place?
All within the ICC, and it's the same for the ICTY and the ICTR. So you have trial chambers and the trial level, and then you have appellate levels. So that's, you have more than one appellate level within the system. So yeah, the processes can be quite lengthy given all that they take on, but there is both a trial and an appellate process within the International Criminal Court or within the other international criminal tribunals.
Great. Now we have a question coming in from Hari, and it is, who is the competent international authority to determine the crimes that attract ICL? And the question goes on to say, in many cases, national authorities may not agree that such crimes have taken place in their territories. So if you could perhaps first address the question of how at the international level might an international crime be defined, what that process looks like, and then perhaps you could then address sort of, I think, what becomes more of a political challenge, and that is sort of the non-prosecution of crimes by national authorities.
Right. So, I mean, why, if we look back at why the international military tribunals after World War II occurred, I mean, quite simply, they occurred because the Allies won and the Allies imposed the international criminal tribunals on the defeated Germans. And while that's been criticized as victor's justice, and of course it was victor's justice, we often forget what happened after World War One. After World War One, Germany was largely left to handle essentially its own business, to hold those responsible for World War One or for committing misconduct during World War One responsible, and those efforts proved insignificant and ineffectual. So I would stress, whenever we want to take a look at the international military tribunals after World War II, we should keep in mind that the international community did try something very different after World War I, and it just didn't work. So, I mean, essentially, someone is prosecuted at an international tribunal one of a couple of ways. One is you have lost an armed conflict, as the Germans did in World War II, and you have a tribunal imposed on you. And then the other is you have signed up for a regime. You signed up for a tribunal. So in the case of the International Criminal Court, states parties to the International Criminal Court have essentially signed up for the possibility of one of their nationals being prosecuted in the International Criminal Court. The ICC is interesting because there's several different ways by which a case can be initiated by the prosecutor at the ICC, but one of them is by referral from the Security Council. So there are most certainly different ways in which a state or its national may end up in front of an international criminal tribunal. In the case of, again, the International Criminal Tribunal for Yugoslavia and Rwanda, I would submit those were victors imposed on the vanquished. In the case of the ICC, it's largely been countries that have signed up for the ICC and have even asked the ICC to look into matters or situations. But there also have been instances where the UN Security Council has essentially instructed the International Criminal Court to consider a matter. So there's several different ways by which a country or its national could end up in front of an international criminal tribunal. Now, in terms of the recalcitrant state, the state that says, we don't think anything happened, or if it did, it's none of the international community's business. I mean, arguably, that's what's been going on with Sudan now for some time. And you would have seen the media coverage. There are essentially warrants out for President Bashir, and every time President Bashir travels outside of Sudan, there is controversy and debate over whether or not he should have been arrested or detained in these foreign countries. At the end of the day, we're only going to have the international criminal justice that we, the states parties, the states and the international community are willing to provide.
Thank you, Chris. And I think I'd like to now pose our last question with an eye to the time. And I think this follows on nicely the response you just provided. So the question is from Trafuso, and there's been and he asks, there's been a campaign by African leaders who seem to be the majority, in quotation marks, the majority subjects at the ICC to withdraw their membership based on what seems to be an unfair application of ICL. What effect would this have on the crimes pending before the court, let's say on the cases currently before the court, should these countries decline to cooperate with the court?
Okay, thank you. The short answer is I'm not sure what the outcome would be if a state who had agreed to participate, be a state's party to the Rome Statute, actually issued its notice of intent to withdraw. My suspicion is you'd still be bound by your prior agreement, at least in terms of the cases that were proceeding. In terms of Africa more broadly, Africa is, I think we're going to learn an awful lot about, and we're learning an awful lot about the International Criminal Court through what is happening in Africa. It's important to keep in mind the majority of the cases and situations before the International Criminal Court came not because the ICC asserted jurisdiction on its own, other than the case of Kenya, but because African countries requested that the ICC look into and prosecute and initiate cases. So to some extent, I can be a little frustrated with some of our African colleagues who overlook the fact that their country may have asked the ICC for its involvement and then seem upset at the fact that the ICC is in fact involved. I think the ICC at the start, I think the ICC was surprised by countries requesting the court's involvement. But my sense is, while initially surprised, the court thought it was a good opportunity to frankly establish and prove that the court is not threatening, that the court is not trolling the world looking for cases, and that these initial cases could help the ICC figure out its processes. And some of that is, of course, ongoing. But the African contingent as a voting bloc is the largest and one of the, if not most significant, blocks of states parties to the Rome Statute. So withdrawal of a substantial number, or certainly all of the African countries from the Rome Statute, would be devastating for the proposition or the prospects of the court's continued viability. One thing that I hope we are able to reach in the International Criminal Court that doesn't currently exist is a transfer mechanism. Ideally we want countries or states to be able to prosecute and conduct their own proceedings. And with tribunals like Yugoslavia and Rwanda, there was a transfer mechanism by which a case might start in the ICTY or ICTR, but then could be transferred back to another country. And so to look at the case of Uganda in the ICC, Uganda most certainly requested that the ICC handle certain matters relating to the Lord's Resistance Army. And the ICC has initiated several cases. At the time that Uganda made that request, I think it's fair to say, and indeed Uganda put in writing, that it didn't have the infrastructure, the capability to conduct the investigations and prosecutions. That was some time ago, and there have been significant reforms and improvements in Uganda. And Uganda subsequently has asked for those cases to be returned to it, which, from my way of thinking, should be the goal. We should want less cases at the ICC, not more. And so hopefully the states parties will look at a transfer mechanism by which countries are able to request cases be transferred back, not only just transferred to the ICC.
Great, thank you very much, Chris, and what an interesting proposal to end on. We very much appreciate you taking the time to present today, and it was an incredibly clear and enlightening exposition of what can be a rather complex topic. So thank you to Chris, and thank you to all of those who tuned in from around the world, and were very active in the chat and submitted some excellent questions. So with that, I'd like to close out today's session with a reminder of the assessment code, which is 1521. And also a reminder that previous recordings, resources, including suggested readings for today's session, they all may be found on the PHAP website, phap.org. The assessment may also be found there for previous sessions. If you're interested in taking today's assessment, you will see the box pop right up on your screen after we conclude. We hope to see all of you at our next session, which is October 14th, and that's when we will be discussing in detail the rather also complicated concept of direct participation in hostilities and what that means for the use of lethal force during an armed conflict. I would also like to take this opportunity to remind you about a series of events that PHAP is hosting, looking at humanitarian principles in practice. We've already discussed humanity and impartiality, and looking ahead, we have a session coming up on Thursday looking at neutrality, a session next Tuesday on independence. And lastly, I'd like to highlight a very interesting session taking place on October 8th in cooperation with Handicap International and the Norwegian Refugee Council, and that's entitled The Realities of Being Principled in Today's Field Operations. These are all in the context of looking ahead to the World Humanitarian Summit. So a number of incredibly interesting events coming up online at which we hope to see you. And so with that, I'd like to say a thank you to Marcus Forsberg and Saranjana Das, my colleagues at PHAP. Again, a thank you to Chris for joining us today, and a thank you to all of you participants who tuned in. Have a lovely morning, afternoon, or evening.